Hello, my name's Frank Fee and I'm a barrister at 1KBW. I practice mainly in family law, but I sit as a recorder in the criminal courts as well.
Hello, I'm Caroline Harris. I'm a barrister at 1 King's Bench Walk, and I practice in both criminal and family.
We were discussing the challenges that are going to be arising now, as have already arisen, I think, in criminal cases, but are going to be arising in family cases. And one that struck me, apart from simply getting to grips with the rules and the mandatory nature of the rules and making sure everybody's au fait with all of the rules, is this notion of having to write out your cross-examination in advance and, if necessary, agree it with other parties and indeed have it approved by the judge. And the degree to which that really restricts the way in which cross-examination can take place. Because my experience so far is that we sometimes allow half a day or sometimes even a day for a child witness to come to court or be elsewhere and give evidence. But because of the nature of the exercise we have to conduct, a series of 20 or 30 anodyne written questions are asked. There is no opportunity to follow that up. And the sense that you get is that no real testing of the evidence is actually occurring. Is that the same in crime?
Exactly the same. I mean, the process of Section 41, so the applications where we have to make in relation to sexual offences. In sexual offences cases, we're not allowed to cross-examine about a complainant's previous sexual history without making an application to the court. And as part of that application, we're required to provide our questions in advance. Now, that means that very often the Crown will go off and take further statements from the complainant, so they're almost on notice about what you're going to ask. You're restricted to those questions. So an area which might, in fact, in front of a jury be one which would give them a character of the complainant, or at least you'd be seeking to introduce some area of lack of understanding of the complainant's possibly in relation to consent, you will lose that reaction because she will already know what's coming. And so actually, and if she goes off to a tangent you weren't expecting, you can't just follow that tangent as you would naturally do so in cross-examination because you have to move on to your next question. So yes, for years we've been suffering in Section 41 applications of the lack of ability to properly cross-examine.
Do the witnesses in criminal cases have advance notice of the questions or the topics or anything of any of that sort?
So it's not the questions, but if a police officer has said, well, actually, we don't know about that area of her previous sexual behaviour, so we'll go and investigate that. So in effect, she will be, or he or she will be asked questions and a further statement taken, which means that they are now aware that that's part of this case. Whereas actually it does give them advance notice.
In Chapter 1 of the handbook that we've written, we set out, don't we, the requirement, the right, in fact, of people who are accused of things properly to be able to test the evidence and properly to be able to cross-examine the people who've been accusing them. And it seems to me that one of the problems that we have, and an emerging problem is going to be, I think, the difficulty of not being able to do that because of the manner in which you're required to ask questions. I mean, if your intermediary in the case goes through your list of questions and changes them to make them more understandable, it's impossible not to change the sense that you're getting at or the direction in which you're trying to go, and may well stop you being able to test the evidence the way that the law is meant to allow. I don't know whether in criminal cases there's been any attempt to, whether there's been any appeal or any sort of process by which this way of asking questions has been tested or examined.
Well, in relation to both children and also in relation to sexual offences, we have had cases go to the Court of Appeal. In most of those cases, the view has been that we can properly address the lack of an ability to cross-examine fully in our speeches, so it can be set out to the jury that we haven't been able to ask all the questions we would do of a child witness. For example, with children witnesses, we often find a judge will say, you don't need to go any further, you can deal with inconsistencies, for example, in your closing speech. Well, very often, when we're cross-examining on inconsistencies, that's the area where a jury will see whether somebody is compellable or not. But if that right to put that inconsistency has been taken away, you may not think that simply highlighting it in a speech is sufficient. It might be sufficient for somebody who has regular practice in front of jury trials. But very often juries are there for the first time, hearing their first case. So in fact, actually, they won't understand the ability, and it's not even an understanding, they won't have the experience of seeing witnesses regularly to know whether that lack of compellability is there or not.
I think in family cases, the lack of a jury, the presence of a judge who is the fact finder, decision maker, and totally in charge of the evidence in the case. I don't want to get cynical about this, but if you are a person accused of sexual abuse or physical abuse in a family case, you will do very well indeed to resist findings of fact against, let's say in particular, a video evidence of a child alleging sexual abuse against you, even if, as has happened in a recent case in which I've been involved, that child subsequently retracts that allegation. The percentage of findings made as against not made is significantly higher than the sort of conviction rate there is in a jury trial, it seems to me, from my experience in these cases. And so it seems to me in family cases, it may well be even more important that you're given some latitude to test the evidence, because you're testing the evidence in front of the person who decides both the law and the outcome.
And very often your burden is different. I mean, our burden is beyond reasonable doubt, whereas yours is on the balance of probabilities.
And often if you're acting for a parent, it feels like having to disprove on the balance of probabilities rather than allow the other side to prove. So it seems to me that a future challenge may well be the way in which we are allowing these children to be cross-examined in a way which is sympathetic to them, but which might really be cutting across the Article 6 rights of a person requiring a fair trial.